on the and trying to get that, compel the answers to that through the rules of civil procedure. You know, the commission has adopted the civil rules as a way of governing the proceedings, governing the conduct of the parties that appear before the commission. The rules require certain things, have procedures for following through with certain things, and that's what we've done in submitting discovery requests, but getting incomplete discovery responses. I tried to work that out with respondent prior to filing a motion to compel, but we've not been able to agree on how to resolve those differences. So that's why I'm back with a renewed motion to compel. What I'm asking the commission to do is to compel responses, complete responses to the interrogatories, which I believe the commission has done previously. And then I have pointed out in my motion how some of the responses are incomplete. I believe respondent has waived any objection to not responding to the discovery requests by not filing responses in a timely way. But yet I'm back here again asking to compel. As part of a sanction, I believe an appropriate sanction would be that respondent should not be permitted to discuss anything that he has not provided or supported through his discovery responses. He has not provided authenticated medical records. That would be an appropriate sanction, would be to prohibit respondent from mentioning any sort of medical condition as an excuse for his conduct at the adjudicatory hearing. We have also discussed today issuing another subpoena or issuing a subpoena to LRC. I'm happy to join in that effort to get an LRC report. Regardless of whatever course of action we take after today, I believe is going to require a continuance of the hearing on December 2nd. And so I would ask that that hearing be continued as well. I do believe I should have an opportunity to subpoena the healthcare records, the medical records. We can keep those records protected, as I've previously discussed, with an agreed protective order. I'm not the one who has made those medical records an issue. The respondent has. And the respondent has produced incomplete and inconsistent records. So I believe I'm entitled to see the supporting medical records and see where the inconsistencies rise from. Thank you.
Ms. Whites.
I'll be very brief. I think the pleadings really lay it all out. We are not providing medical records for the reasons we've discussed at inordinate length. We have fully complied with all the other discovery and given everything that Mr. Grossberg has in his possession or that I have. I don't believe there is anything still outstanding.
Are there any questions by any of the commissioners, first of all, present here in the annex? Is there any questions from any of the commissioners that are appearing via Zoom? Okay. All right, hearing none, and I think this may also, some of the subject matter here bleeds over into some of the other motions, but the next motion is a motion in limine filed by Enforcement Counsel. Mr. Jenkins, I'll ask you to start there.
Thank you. The motion seeks to limit the focus of the commission to the issues that are before the commission, which are the three ethics charges, the three ethics violations for which the commission has previously found probable cause to support. Did the respondent intimidate Foxy's? Whatever motivation of the complainants was proper or not, it's irrelevant to whether he tried to intimidate or did intimidate Foxy's. Whatever the motivation was, or even training was that respondent had, is not relevant to whether he offered to do the Subway owner a favor in exchange for a donation, and whether he became intoxicated in his office and asked Emma Curtis questions about her sexual habits while drinking 5 to 8 shots, maybe less by his testimony, but more by hers. That's the issue, whether he did that. The complainant's motivation in filing a complaint is irrelevant because you've already found probable cause to believe that a violation occurred. I spelled out very specifically the types of things that I would ask the commission to limit or to prohibit the introduction of at hearing. That's the purpose of a motion in limine, is to just preclude up front. It would make the proceedings go a little bit more smoothly by just up front saying, okay, we're not going to allow these types of evidence or these specific things to come in later on. I mentioned the motivation. We've talked about that. Evidence of bullying, that's not relevant to these three complaints. There's been discussion as to whether the complainants had direct knowledge themselves of these three allegations. It's not relevant. We already have evidence of the people who will testify about those allegations. Testimony of persons who did not witness or have knowledge of respondents' conduct involving Foxy's Gentlemen's Club. Just seeking to limit the testimony to the specific charge. I had in my motion 24 or so different items. I don't think it's, I think a lot of these have already been discussed. I'm happy to go into them in detail if the commission would prefer. I don't think it's necessary. Most of them go to the motivation. There are complaints about religious discrimination. Those aren't relevant to these final three charges. There's been discussion about a menu and food that was offered. That's not relevant to these final three charges. Reference to LRC policies isn't relevant to whether respondent committed violations of the code of ethics. Again, I went into considerable detail here, but I'll say the last most important one, I believe, is any evidence that respondent had a mental or physical condition that, and then I listed the items here as to how they have alleged that conduct or that mental condition may be relevant. If we don't have supporting records, I don't believe he should be able to testify about it. in order to testify about mental health conditions, he should have to produce medical proof on that. This is not like somebody who has a broken leg and you can look at that person and say, oh, they have a broken leg. They're going to have trouble walking. These are mental health conditions that will require, in order for it to be considered by the commission, it should require expert proof. And we don't have that. And they're attempting to block it. In order to, they said, well, you can call these people at the hearing. That's not incumbent upon me to make their defense. What is incumbent upon me is to thoroughly investigate the matter, and that includes obtaining the medical records that are relevant to the issues that they have raised. And that's what they have sought to block. The claimant's past dealings with the respondent are not relevant to the final three charges. The irresponsibility of the Lexington media that has been raised is not relevant to these final three charges. LRC's investigation that related to LRC staff is not relevant to these investigations. As I stated, I am happy to join in a subpoena, and we can get that LRC investigation. Respondent could have done that, but again, this is not a proceeding before a board such as, we'll say, a board of nursing, where the board of nursing is saying our policies were violated. Well, show us what policies were violated, and they would have to turn that over. This is a proceeding before the Legislative Ethics Commission. What the Ethics Commission has to disclose is which violations of the ethics code are being alleged to have been violated. And that has been specified. The Ethics Commission does not have to turn over or does not have even a responsibility to obtain anything from LRC. And LRC has made that very clear that they did not intend to voluntarily provide that information. I think there is conduct that we can all agree is appropriate and not appropriate. When we go out and we make threats to people, I think we can all agree that conduct is not appropriate. When we go out and we make offers to do something in exchange for something else, we all might suspect that there could be a potential problem with that. When we're drinking in our office and at the same time questioning somebody about their sexual habits and body parts, I think we can all agree there could be an issue about that. The extent of respondents' conduct is the issue here. That's what I'm seeking to limit, to keep the focus on. What was that conduct? That's the purpose for the motion in limine, to keep out certain kinds of ancillary, off-topic evidence that's been discussed more thoroughly in the motion. I'm happy to answer any questions.
Okay, Ms. White.
I'll keep it brief because I think we've hit on most of these. First, I think it's laughable to, having seen Representative Grossberg and the bouncer and manager at Foxy's, that he could intimidate them. But categorically he did not. I think the concerns about motivation and bias relate to the fact that the only people who say that he made any sort of a quid pro quo offer are two young men who were employed by the complainants. I think the Foxy's motivation and bias play into that because the only person who was part of the complaint is a friend of one of the complainants. I think the whistleblowing and the bullying is relevant because the attacks on Representative Grossberg did not happen until he made a complaint to the complainants, hey, one of your staffers is sending really inappropriate texts to young interns and pages. Please have a discussion. And at that point, the complainants began to bully him and look for reasons to get him in trouble. And as we see from the initial complaint in particular, most of those were made up or false or incorrect. Discrimination is always appropriate to bring up. When somebody is being attacked and harassed systematically, that is a relevant reason this commission needs to look at not only and it's a he said, she said, and in most of these cases, the Foxy's people who testified were not present. The two young men who allegedly heard the quid pro quo conversation are not present. So it's going to be a case based on a lot of, well, I heard, I saw this, I thought of that. It's very important to try and realize that the people who started this complaint and pushed it forward and the second complaint are all related, all working together, and it all stemmed from that whistleblowing initial complaint. As we know, the LRC investigation, we believe, is very important, because if you have an investigation, and that went not just to LRC staff, both complainants and Representative Grossberg said they interviewed lots of people, looked at lots of texts. And so that's vital. These are all important parts of the defense, and more than that, important pieces to help the commission understand, did this actually violate the legislative code? And the only thing he's been charged with is doing these things for personal benefit. Well, the subway was a caucus fundraiser, so it didn't benefit him at all. And discussing issues, and there were sexual issues with a sexual bill or gender-based bill and a surgery-based bill and medication-based bill with an advocate who, as one of the complainants admits in her deposition, had the same type of discussion with her in her office. Those are all relevant. That information plays into this. We're not planning to bring 30 witnesses in to attack anybody, but we do need to focus on the why this happened, why these issues are present, and why we only have witnesses on the complainant side who were paid by the complainants and worked with them. So I think it's important to let that evidence come in. If there is something in the moment that the commission finds an appropriate, rule on it then, but do not dismiss those valid arguments and that valid question before we even get to the hearing.
On the benefit, it is a benefit on, as we were talking about, what benefit did he get relating to the subway? It's a benefit to himself or to others. So that's critical here as well.
Well, the donor didn't donate, and the donor also
the
didn't
attempt.
get on the
It's
list.
the attempt.
And there was no attempt. Both
There
parties
was-
involved say there wasn't. That's the evidence you hold in your hand.
Both parties involved did not. You've already heard it. The two people who listened in on the conversation
And are paid by complainants.
had a contract we're not employees with, and they had a contract at the time and no longer have a contract with them.
But did for a year after.
And you're speaking of a matter then that goes to credibility, possibly, but then the respondent takes that information and contacts legislative leadership and says, how can I make this happen? So, yes, there's
That
more.
is not, I mean, that's
There-
mischaracterization. The test says, how does somebody sign up for the vendor list? Those texts are in the record.
Because he thought there was a state catering vendor list, which there wasn't. But he thought the attempt was to obtain a benefit in exchange for something. That's the violation here. So clearly we have a difference of opinion as to facts that will come out, and that the commission is entitled to hear. But whether respondent believes that he suffered religious discrimination is not at all relevant to why we are currently here facing these three with these three charges. Why I agree that if we can get more information from LRC, Absolutely. Let's see what LRC has to produce. And if it's relevant, it's relevant. But if they are going to say, what was the complainant's state of mind in bringing these charges, then that opens up all of the charges in the complaint. And that is why we will then have a lot of additional witnesses. Because if those witnesses don't testify, then there's going to be objection about hearsay. And if we're going to go to credibility of what of why the respondents filed the complaint to begin with, then we should be able to hear from all of these other witnesses. I don't think any of that is relevant to the final three charges. But if they're going to say, well, there are these other things, why didn't they do this here, then, or there? Doesn't matter as to why we have probable cause today on these three charges.
The credibility of a witness is always at issue, and when witnesses are employed by or paid by complainants, we do have to ask ourselves, did that influence in any way the statements that they made, particularly when there's no recording, no contemporaneous notes from them.
Are there any questions by commission members here that are present on this motion in limine? Go ahead, Mr. Chairman.
Mr. Jenkins, your motion asked the commission to grant in entirety. That's a lot of territory. Is it still your thought that needs to be granted in its entirety, or are there parts of it that you would think are more important or less important? Because it's a lot to consider in terms of having it granted in its entirety.
I understand, and as far as yes, sir. A lot of times when attorneys file a motion in limine, they're spelling out a lot of different areas, and then they go into they argue that motion before a court, and the court makes rulings on the different things in different items in the motion, and that's the intent here, was to mention the different things that came to mind that I thought were not relevant to the adjudicatory hearing, but the commission is certainly free to decide on its own which of those items it believes is relevant or not.
Okay, thank you.
Any questions by any of the folks on Zoom? As the chairman mentioned, so in the motion in limine, there are 24 different topics, some of them with a few subparts. So I think probably there's 30 different areas, I guess, that enforcement counsel is asking be excluded from evidence. And maybe it's a dumb question, but I'm going to ask it. Is there anything, Ms. Whites, that you could agree, yes, one or two or three of these? Like, for example, the number 17, I'm just using that as the first one. Any reference regarding irresponsibility of Lexington media in reporting on respondent. I mean, that's not relevant, is it?
I believe it is relevant. I mean, that one may be a longer walk, but the facts that the complainants are close friends with the reporters reporting on this, I think is relevant to point out, because a huge swath of our community is only reading that paper without being aware that the reporter may be biased one way or the other. We don't see the same type of reporting coming out of Louisville, even though this is a Louisville state rep.
But what relevance does that have what we're doing here? Like, right, I mean, what they write in the Lexington paper, I'm not intending to make that part of the, like, go and read that and then say, okay,
Correct.
That's part of
but
this case.
But if a witness has shared false statements with the media and then is testifying before this body, you might wonder if that witness's credibility is impacted. I'm not saying necessarily, we're not going to haul Austin Horn in here and ask him questions. I'm just saying that impacts witness credibility. If they are feeding false statements to the media and ginning up that kind of overblown false claims. I mean, this case, if these three charges had been the ones in the media, the way this commission has laid them out, we would have gotten 1 column inch. The column inches have come from false claims that the complainants themselves have put in the media and have persisted in bringing back up in the media over a 2-year period. This has impacted 2 sessions, and we hope it doesn't impact a third.
What about any, I mean, just while we've been sitting here, you've made references to, well, other legislators do this and other legislators do that. What relevance would that have?
That has no relevance other than when it comes to if other legislators are drinking in their office, particularly where it's leadership, or taking gummies, THC gummies in their office, or discussing issues with advocates after hours in their office while drinking. That would lead Representative Grossberg to believe, as a freshman representative, that's what we do here. And both complainants of the initial complaint said, we did that, everybody did that. So it's only relevant as to Mr. Jenkins saying, well, he should have known not to do that. No, he shouldn't have. They all saw it happen. They saw their leaders do it, laugh about it, and talk about it.
But
so
it's-
they thought it was okay.
But they don't have, the other legislators don't control, first off, what we're looking at and what we're matching things up to
Right.
is the legislative ethics code.
Right.
That's the code, right? So, I mean, any representative, any state senator has the ability to go and say, well, it says right there you can't do this.
But the
right?
code doesn't spell out you can't drink in your office. You shouldn't be drinking on taxpayer time. You shouldn't be taking THC gummies while you're engaged in operating the legislation of this Commonwealth. But he saw that. The code similarly doesn't say you can only ask an advocate this many issues about trans bills and rights and life, but not these. This is a case of nuance. And so while I don't think it's relevant, some of the things in various motions and many of the pages in the deposition, while shocking and embarrassing, are not things that we want to put in the record in this hearing. But there will be certain behaviors by the leadership who are charged with leading him and training him and showing him and his freshman peers how to act, failed to do that.
But whether or not something is the norm or not, or whether or not some type of activity is prevalent by legislators does not affect whether or not it is a violation or not a violation. In other words, what I'm saying is if a majority of legislators just decide that they are going to act in a way that is a violation of the ethics code, that doesn't make it not a violation of the ethics code. Like if I'm driving back to Louisville today and I'm going 95 miles an hour and I get pulled over by a state trooper and I say, well, everybody else is going 95 miles an hour. They don't just say, you know what, you're right. I'm sorry that you happen to be the person that I pulled over, right? I don't see how the notion that it is prevalent conduct necessarily excuses it.
Well, in your case, there's big signs that say drive 55.
And
You
there's a
get
statute that
trained,
says you
get
can't
a
do
license.
this.
The
That's-
statute doesn't say you can't discuss certain issues with an issue advocate. It does not say you can't discuss state catering lists or how to sign up on a state procurement list. It doesn't say that you can't say to a business, I'm angry with you, if in fact that happened, or I'm threatening you if in fact that happened, which we deny. This is a case where if there had been training, thou shalt not drink in your office, that wouldn't have happened. If there had been training, you shall only talk within this box to people. You shall not reference these. But there was no training, and worse, if it was your boss or the governor or somebody else who said, there's no law, let's all drive 95. Odds are good your district judge is going to be letting you off in that
Well,
situation.
Go ahead, Mr. Chairman.
Are you're sort of suggesting that there's some entity that has responsibility to advise incoming legislators about their actions?
Correct.
I'm not aware of that. I've been around the legislature for a long time.
This body actually provides a chunk of that training that is mandated by statute, and then each office also trains and advises its
You're
members.
right, but I mean, it's incumbent on every legislator to learn the ethics code, to abide by the ethics code, to read the ethics code, be familiar with the
And
ethics
it's
code,
our contention
and to
that he did.
understand that they need to call this commission if they have questions,
He also
which
did
they
that.
do
Yes.
mostly.
And he did all those things. However,
there's
his
no-
leaders were showing him a very different standard of behavior that may have led to the actions in these complaints. If you were
I'm ju-
if
I'm
you
just-
have somebody making soliciting phone calls, whoever you are, the Red Cross, the carpet store, you train those people how to make those calls. That didn't happen. And it's the same across the board, not just for these charges, but for many others. So while that may not be relevant, it also goes to witness credibility and bias. But
are
there
you-
are certain things you don't know if your leadership doesn't make you aware of.
But are you contending that the training that they receive is inadequate?
Yes,
And-
I don't
and
think
whose
2
fault
hours is enough.
And whose fault is that?
That would be the House leaders. I don't think this body is responsible.
But you see,
for doing
that's,
that.
I mean, I've known a lot of legislators pass through the system. I came up here in 1974. I've never had the impression that anybody felt needed to educate them about what they could do and what they could not do.
Sir, I led the training for more than a decade, twice a year for all the House Democrats.
I
And I
understand.
believe the Republicans did the same thing during the same time frame. There has always been training.
No, there hasn't always been training.
Well, no,
okay?
obviously there has not always
You
been
know,
training, but there
I'm well
should
aware-
be. There should be training.
I can go back to Kentucky Dam Village, and it was way back.
Yeah,
and,
yep.
You know, there wasn't
I
any training about
remember
any
that,
ethics
but there
down
should be. We learn from
I
the
guess-
bad things that
I
happen,
guess what I'm
and we
thinking
do
is
better.
You're trying to place responsibility on somebody or something for not having trained this individual not to do these things.
Or train
And-
those with complaints how to bring them before it turned into what leaders describe in their deposition as a massive gossip session with everyone saying, and I hate him for this. I've always thought he was strange. Training prevents all of that. That's why in every workplace you are in, all of us, you are trained on all these issues. Every workplace.
But what I would submit to you is that your interest in training is not appropriate. I mean, it's not going to happen. That doesn't happen with anybody. I mean, these people come up here, they go to our training session. We have a freshman orientation where they get to learn about being a legislator. But by and large, you don't train them a lot. They have to read, they have to understand, and they have to do what's right from the beginning.
Correct. But
And-
there is a difference in the way many of the legislators you know and work with behaved and learned and what their leaders modeled and taught them and what happened in this instance. There was a couple-year gap there where things just went to heck in a handbasket. And that's unfortunate. And that may be, as we move through the matter, relevant to why some of these issues arose. I do not believe there is a violation of the ethics code. I don't believe you can find one reading it and looking at this case. But I do believe a misperception occurred, and this complaint arose partially because of lack of training.
Okay.
Let me ask you, you both agreed that you feel that you would subpoena together the records of the LRC. Does that mean that both of you all agree that this hearing should be continued
No.
from December 2nd?
I do not think we should impact another legislative session. Representative Grossberg has struggled through 2 years with all the false media information out there, and making him go through a budget session like that is bad, and bad for his constituents, bad for the Commonwealth. This matter needs to wrap up and be done.
The adjudicatory hearing absolutely must be continued. The failure to timely object to the discovery request has greatly impeded my ability to be prepared, especially when I have anticipated that I should be getting medical records to evaluate the authenticity of claims that respondent suffers from various medical conditions, which, according to the reports we have, he may or may not have.
See, I think it's concerning when your own counsel is saying this legislator lied under oath. I think this is the fundamental problem that we are having with this.
Excuse me, I didn't interrupt you when you just spoke, and I did not just say that respondent lied under oath. What I said was that the medical records or reports themselves are not consistent. And that is what he wants you to rely on, and allow him to address his medical condition. I need to see those medical reports to know how to properly examine, or the medical records, to know how to properly cross-examine the respondent. It does go to his credibility in talking about the treatment that has been recommended for him, and his decisions to not continue the treatment, especially when one of the providers is suggesting that from apparently from his observation that the respondent was continuing with his treatment and doing so very successfully. What I've asked is that respondent merely abide by the requirements of the rules of civil procedure, which this commission has adopted. And asking questions about why information hasn't been provided does not mean I don't believe somebody. It doesn't mean I'm casting some ill intent. I'm just saying I'm entitled to have this information produced in the appropriate way, according to the rules that have been adopted by this commission. That is all. And the inability to get that information has, well, it has placed us where we are today, where I still don't have that information, and now we're talking about a subpoena of LRC. And I agree. I think that subpoena would be a good thing. But we can't get that information and digest it and do anything with it prior to December 2nd. And it also goes, of course, to the motion to compel and getting medical records then, because respondent has said that they would take any other order to Franklin Circuit Court, and I welcome that. I think they should take it to Franklin Circuit Court and make the argument in Franklin Circuit Court that the rules of civil procedure that have been adopted would support their position that the commission is not entitled to see and have properly authenticated medical records on a condition that respondent has raised as relevant to these last three charges.
Mr. Jenkins, let me ask you this, not to interrupt, but between, let's say, two different goalposts here. One is the letter or letters that have been attached thus far from the MD and full-blown medical records. Is there something that is greater than just the letter, but not the full extent of the full medical records, meaning if respondent has flat feet or something like that, that would seem to be irrelevant to the conditions that counsel is saying they intend to raise at the hearing? Is there something that is more narrow than the full records that you think would satisfy your needs, but beyond which you think is of not necessarily fully probative.
Yes, yes, I'm sorry. Yes, certainly.
And
The-
what-
The records relating to the diagnosis and treatment of these conditions. That's, any other healthcare condition I don't need to know about. But the conditions that have been raised here in these reports are relevant, and those are the records supporting those reports are what I believe I'm entitled to see.
In terms of the let me see if I can maybe narrow that even a little bit more. Would you need, and I don't even know how such diagnoses are made, but are you asking for, say, the doctor's transcription of all the different things that the representative may have told this person over time leading up to the diagnosis, or just the real-time, at the time diagnoses itself, or something in between? I'm trying to see if I can get you to say, well, it could be more narrow than what has been asked for, but it's more than maybe what Ms. White's has provided, but that there's some way we can narrow that.
I think we could narrow it to go back to, we'd have to go back to when I believe Dr. Olson was treating respondent. I don't know when that was. I don't know whether he last treated him in 2008, 2010, 2019. But as far as Dr. Olson's records, and again, I don't know if it would be a subpoena of Dr. Olson, because I don't know. I don't think he maintains a practice. I don't know where those records are. I presume they might be at the University of Louisville. They might be with the Department of Neurology. I don't know. But if we had been able to explore that prior to today, we'd be a little closer, I think, to being able to have an adjudicatory hearing on December 2nd. But the short answer, I'm sorry, is that no, I don't need all medical records. I just need supporting medical records for the reports. And I don't appear to have any treatment records of a provider. Again, I'm not impugning any provider. I'm reading the report itself. Dr. Olson aside, I'm presuming he hasn't treated respondents since 2019. Dr. Frankel doesn't say that she's treating him. And again, it's just a report. If she is treating him, then I need to see, why is it she says he's not following the treatment protocols that Dr. Olson says he is? I don't know that I need the records of, I think Hillary Seymour, I believe was the other person. I don't think I need her records. I think since she's, I don't think the allegation is that she's treating him for these conditions. If she is, then I would need her records. But I don't know that.
She's
Okay.
his therapist, so obviously she is.
Okay, I'm sorry. So her report says nothing whatsoever about ADHD, autism, neurodiversity. Her report only talks about addiction. And so it says nothing about the other things.
Okay.
Her report confirms that he does not have addiction and has not ever had addiction, because that had been a question you had requested answered.
Let me get back to the larger motion in limine here, because there's a number of things that let me put it this way. Let me approach it from this angle. I know that your exchange of witness lists, even with the hearing currently scheduled for December 2nd, that the witness lists were going to be, I think, exchanged on, like, in the next few days, right? How many witnesses do each of you I understand maybe you could add another one. I'm just asking if you know approximately how many witnesses does either party have that you're intending to call during the hearing?
Our list is short. I would say probably 5.
Okay. I'm not holding either of you to, no, you can't say a 6 or something
said
like that. Now,
5.
I'm trying to get because I'll let Mr. Jenkins answer, and then I'll kind of tell you why I'm asking this.
If we're going to be talking motivation to file a complaint, then we're looking at 20, which would include a couple of people on Foxy's, a couple of people on Subway, and Emma Curtis. So 5 at least, I think, that are relevant to the charges, and then potentially the complainants and potentially other people who reported things to them that ultimately helped support a decision to file a legislative ethics complaint. I don't think a lot of that is relevant. But if we're looking at what Dr. Olson might say, or Dr. Frankel, or I don't think she's a doctor, but Ms. Seymour, then I may be looking at trying to take discovery depositions of them. If I can't get the records, I don't know how. Respondent is saying we're going to bring this information up, and you can call these people. Well, that's not my burden. It should be them. They should have to call them. They may still call them, but if they do, I need to know what they're going to say. Again, that's why getting their medical records would allow me to know what they would say, because I would have those records.
I'm asking this to also not just get an idea for the amount of time that a hearing may go. Thinking back to the probable cause hearing, the fact that did have to spill into a second day just with that number of witnesses. But there's also the issue of, I'm looking here at a number of different subject matter areas that have been at least thrown out there in things that either party, and Ms. White's mostly respondent, has filed and talked about. Bias, other people do this, the training and things like that. And I think as we're sitting here, there do seem to be some of these that are of minimal, if any, actual relevance to, did the representative do this or did they not? And I understand you're saying, well, maybe bias could go to the credibility of a witness. But what I think everybody is very intent on is this cannot turn into a zoo in terms of a hearing where it's just, let's throw out all things about everybody that's not even here, and making, if there's an accusation or a complaint against a legislator, as we've just gone through in this process, confidential complaint is made, they respond confidentially.
Well, these behaviors, as much as Representative Grossberg's behaviors, are not violations of the code. They may expose those folks to other suits. They may just make them bad people or poor actors. If they were legislative complaints, they would have been filed. But what we're saying is they were motivated to file meritless complaints. against and motivated people they paid and worked for to file meritless complaints against.
Well, if it's a
Representative
false
Grossberg.
complaint, that would be its own issue.
Correct.
And there's not been anything where somebody has filed a complaint alleging that this complaint was false, right?
Correct. No, and.
So that would
and-
seem to me to be the appropriate course of action, rather than saying they're lying, they're biased, and things of that nature would be that.
There certainly could be a separate complaint about false charges, and I think we have referenced that. But witness credibility is always going to be an issue, and the witnesses may not testify, and it may not come up. But if it does, I don't think it's appropriate to preclude questions on witness credibility.
Yeah. Well, I mean, there's all sorts of other. It seems to be a hodgepodge kind of various complaints about, well, at this event they didn't do that and whatnot. And while maybe
We can let the menu go.
okay, that's good.
We'll
Thank
let
you
the
for
menu
that.
go.
But things of that nature where it's kind of like, okay, well, not really relevant to, because what we, as I'm saying, we keep trying to come back to is all we're trying to do is saying, here's a complaint, here's what people are alleging happened, here's what there seem to be witnesses that Enforcement Council has provided or come up with. Here is the Code of Legislative Ethics, and that's what we're looking at. You know, we're not looking at the Lexington media and things like that for the purposes of what we're doing in here. And
But
so
we're
I don't want
looking
to
at
enlarge
witness
this.
credibility. And so if the only witness is somebody who was paid by the complainant, and the complainant, then we can ask questions about that. And I think that's relevant. If the only witness is somebody who was objecting to Representative Grossberg's whistleblower complaint about a staffer, that goes to witness credibility. If the witness is somebody who's done the same thing to other people, then that is an issue of witness credibility. And obviously that places a lot of pressure on you, because some of those calls will have to be made during the testimony, but I don't think you can preclude all of those relevant facts.
Yeah, well, I just feel like we're going to have to pare some of this down. I was hoping that there could be some agreement as to some areas that are irrelevant. Thank you for the lunch and the menu.
We'll give you the menu.
Because I don't think we need this to go on for a number of days and days or things like that. We need to cut to what's really before us. Okay, are there any other questions on this motion? And then we've got one more. All right, so the last motion is motion in limine filed by respondent regarding redacted transcripts, I believe. And again, I ask at the beginning, does anything need to be addressed in a closed session? So please refer to this and don't mention any parties by name, all right?
Yes.
If you feel like you need to, we can figure out how to do that.
I do not need to.
All right.
And very briefly, this is Representative Grossberg's motion. During their depositions, both complainants discussed unrelated and extraneous criminal allegations against several legislators, both of whom are still seated and serving the Commonwealth. We would ask that any page that references those legislators' actions or names, and I believe I listed the pages, be redacted. None of that is relevant to this case, and both of those legislators have expressed some extreme unhappiness and at having been referenced with those false charges. While it is a witness credibility issue, pointing at the complainants, we're not going to burn the Commonwealth down by airing false charges made by the complainants. And so we'd ask that just those pages be redacted from the depositions, so that if they are released or used as evidence, you don't see those names or those false claims. The Commission's counsel in response says, well, tell me what exactly criminal statutes. I don't think we need to go to that. That would be extensive, particularly on, Medicaid fraud allegations. And so I would say it's very easy, do a word search, any page that those names turn up on, X out the page.
I'll let Mr. Jenkins, I will say before that, we haven't seen any of that.
Correct. No, sir.
So
They're
you're
not
telling me
before you.
something about
Yes.
something that I haven't
There's-
seen, none of
yeah,
us have seen.
There's just 10 pages or so, maybe fewer, and on the page, the complainants say, Representative XYZ committed this criminal act, and go on, and they're not relevant to the charges before the commission. And so we'd say, let's just pull those pages out of the deposition, just black out the page and move on.
All right, Mr. Jenkins.
I don't believe there was any, I don't recall, I don't believe there was an instance where one of the respondents said Representative XYZ committed this criminal act. Now, they did talk about some conduct, which has been characterized by respondent as being a criminal act. They have not, the complainants did not on their own relate this information. The information that they related was, perhaps some of the most salacious, was information that respondent gave them. And now respondents saying, "Oh, I don't want this in the deposition." Now, I think they would say, "Well, I didn't say that." The complainants say, "Well, he did say that." And counsel's probably aware that there's at least one other witness that she's had a recording of who heard that statement as well. It also goes to motivation as to why a complaint may have been filed. If respondent is saying, this legislator, someone is doing something to me, then it might explain why a complaint that might have motivated them to go ahead and file a complaint, in part to give protection to respondent, to have something investigated. And then to ask the commission to go through and do a word search maybe for the word criminal, I don't know how you do that. First, you don't have the depositions before you.
A word search for the
Yeah,
representative's
let me ask
names.
it this way. So we do not, all right, just like in regular discovery, you
Yeah.
don't file depositions with
Right.
the court.
And-
all right, so we don't have it as we sit here. If somebody
Yes.
asks us about it, we don't know anything about it.
Right.
Was there an allegation of this or that? So I ask myself, you're saying you want it redacted. In what way would it even come before us? Because if
It will
we've already
be
got
used
your
as
motion,
an exhibit.
huh?
I would presume we would be using them as an exhibit at trial. And so when I use those as an exhibit, I want the page blacked out. The word search would not be for criminal. The word search would be for the specific names of seated legislators who are no part of this action. And that's easy enough to do. There's no reason to be defaming falsely representatives who are serving the Commonwealth in this deposition, but we will need to use it as an exhibit. And so we should just redact those pages. It serves no merit.
The complainants did not defame anyone. They repeated what they had been told by respondent.
The complainant said, this person, you know how we said Representative Grossberg engaged in Medicaid fraud, et cetera, et cetera. Actually, we found out it was someone else. It was this state representative. That's egregious. That should not be in the record. And there are several other instances like that. And it's so easy to redact that page, and that page is not relevant. I don't want to put it in as evidence with mine redacted and his not, because I think two state reps would then be suing me. And I prefer not to have that happen.
If we have specific, first, I don't think entire depositions have to be part of the record anyway. I think if we're offering testimony, certain testimony, we can designate the pages of the depositions to be
Well, we
offered.
plan to make them, we plan to share them broadly once this matter is over.
Well,
But we would like them
that is,
redacted.
Well,
that,
why do we have, when you say share them broadly?
There's
what's-
going to
what's
be,
that?
they're going to be in evidence, and we're going to let the public look at them. I think that they will be a public record. I don't think you can say, Anna, you can only use 5 pages of the deposition. No, I'm putting the whole deposition in there. I just want it not to harm people who are no party to this. Let's just black their names out. Black their
So
pages
I don't
out.
think if both of you are saying that these are specious allegations,
Yes.
that we want to hear about it probably either. So
No.
except, and this is the, and this would be the item that should be discussed in executive session. If we're going to, because we can't discuss the names here. But if something is so important to a complainant because of the person who, because of the allegation against, the allegation is, if there's an allegation against that a particular person said something, and because of, we'll just say a person's reputation in the community is such that, oh my gosh, that person in the community is making this allegation, that means something more to us, perhaps, that this needs to be, it's further evidence that this needs to be investigated, as opposed to maybe a less credible allegation. The name of, I'm not saying every person's name in the deposition would need to be shared, but in some instances, the specific person's name would need to be shared because it does directly relate to the state of mind and potentially motivation, to the extent that's relevant, in filing a complaint. If we're not talking about relevance in filing a complaint or motivation in filing a complaint, and we're only talking about the three issues in front of us, it shouldn't come in. And I don't think the entire deposition should come in. They're not part of the record. They're not relevant.
Do I understand you correctly saying that if respondent is going to say the reason that they filed this complaint is because there's a bias against me, meaning respondent, you're saying actually there could be something in the transcript which would explain why there is a other motivation for filing, an additional motivation in filing
Yes,
the complaint?
absolutely.
And so you're saying if they're both irrelevant, and it's just, it doesn't matter why you make the allegation, going back to my Ohio State, Michigan complaint example, just was there one or was there not? It doesn't matter why somebody would be reporting it. If that's the case, you're saying both sets of additional background information are irrelevant as to somebody filed a complaint because there's a bias against, and maybe somebody filed a complaint because there's an additional reason that they wanted to file it. The reason is irrelevant. It's like, did it happen or not?
Yes, and just as a proffer of deposition testimony of non-parties, because the complainants are not parties here. So the portions of those deposition transcripts that do not relate to these three specific items are irrelevant and should not be part of the record.
Mr. Chairman, can we pretty soon move on, because I'm only going to be able to give you about 15 to 20 more minutes before I have to get off with a palliative care nurse coming.
Sure.
Thank you.
Okay.
I just think if he feels as though that needs to come in as motivation evidence, then that person should be called as a witness, and they should be cautioned not to use a sitting state rep's name. I don't think this is a big ask. I
Yeah.
would just black those pages out, direct us both to do so.
Okay.
They are not parties, not witnesses, not anyone related to this case.
So here's what I think we need to do. We're going to have to go into closed session anyway in order, and Mr. Chair, I'm interested in your thoughts too, any of the commission members. We need to now go into closed session to, I don't know if we're actually going to be able to rule on all this stuff today or not, but we're going to need to probably start. 1 second. So we're going to enter closed session. You know, I asked at the beginning, is there anything that needs to be discussed in closed session relative to these motions? I think we would like to hear just a little bit on this last point in closed session. The reason for the closed session is because both of you are saying that you don't necessarily find the other allegations in the deposition credible. And, you know, in the same way that if somebody even filed a complaint with us, from the get-go, it's considered confidential until you get to a point. And so it's being mindful of that, because it's almost kind of like what you're saying is an allegation. So I want to treat that the same way we would as if somebody filed something, which is to say confidentially at first. So what I would do is I would ask that we ask for a motion for us to go into closed session, but I'd like both.
So moved.
For a second. All right. Thank you.
So
Commissioner.
moved.
Is there a second? Yeah. Okay.
Motion made and seconded. All those in favor of the motion signify by saying aye.
Aye.